Welcome back to SCOTUS Oral Arguments and Opinions. Today we tackle a case that's about civil procedure, but with massive real-world consequences. The GEO Group, Inc. versus Menocal. Does a procedural privilege create a fast pass to an appeal?
This case asks a fundamental question. If you are a private company doing work for the federal government, say operating a detention center, and someone sues you, what happens when you claim the government told me to do it? And specifically, if a district court rejects that defense before trial, does your company get to appeal that decision right now? Or must you first go through years of discovery, summary judgment, and a full-blown trial, potentially costing millions, before an appeals court can even weigh in?
This case pits the efficiency of the justice system against the government's ability to carry out its functions using private contractors. It's a technical, procedural fight that could determine whether thousands of lawsuits against government contractors can move forward or get stopped in their tracks. Each year, the government doles out hundreds of billions of dollars in government contracts. These contracts get implicated in this case.
Before we dive in, let's quickly orient ourselves to next week, where oral arguments will begin again. Here's a quick rundown of next week's arguments. On Monday, November 3rd, the court will hear Rico versus United States and Hensley versus Floor Corp. On Tuesday, November 4th, the court will hear Coney Island Auto Parts, Inc. versus Burton and Haynes Celestial Group versus Palmquist. And on Wednesday, November 5th, the court will hear the Trump tariff cases. Check out earlier episodes for previews of these cases. Two related points. In our Coney Island case preview, we mentioned that case was slated for oral arguments on November 5th. However, the court moved up the oral arguments by one day to November 4th. Also, we previously mentioned that the court will hear Ham versus Smith on November 4th. However, the court pushed back that oral argument to December 10th, likely to make room for the Trump tariff cases.
As another aside, thank you to everyone who has listened, rated, reviewed, and shared. Your engagement truly means a lot to me. I'm heartened that people find the content worthwhile. In just 6 short months, we've grown from 10 listens per day to 500 plus listens per day. Let's keep it going.
All right, let's talk GEO Group, Inc. versus Menocal.
The Supreme Court will answer this question presented: whether an order denying a government contractor's claim of derivative sovereign immunity is immediately appealable under the collateral order doctrine.
All right, that's a mouthful of legal jargon. Let's break down the 3 key concepts.
First, sovereign immunity. Sovereign immunity roots in the ancient legal principle that the king can do no wrong. In the days of the British monarchy, people could not sue the crown without its consent. This principle now affords federal and state governments general immunity from lawsuits unless they specifically waive that immunity. The doctrine intends to protect the government's ability to govern by preventing private parties from constantly suing and paralyzing essential government functions.
Second, derivative sovereign immunity. You can see from the name that this concept derives from the government's own sovereign immunity. When private contractors work for the government, whether they're building roads, operating prisons, or providing security services, they sometimes claim they should share in the government's protection from lawsuits. The theory holds that if the government itself would be immune from a particular lawsuit, then contractors acting under government authority should enjoy that same immunity when they follow government directions. Derivative sovereign immunity comprises GEO Group's core defense. It offshoots from a 1940 case, Yearsley versus W.A. Ross Construction Company.
The third key concept is the collateral order doctrine. Federal courts normally require litigants to wait for a final judgment to appeal, but a 1949 case, Cohen versus Beneficial Industrial Loan Corp., created a tiny exception for a small class of collateral orders. What this really means is that a small set of orders can be appealed immediately if they 1. conclusively resolve an important issue, 2. are completely separate from the merits of the case, and 3. involve a right that would be effectively lost if you had to wait for the final appeal. And the classic example of this is a district court's denial of qualified immunity for an official. The Supreme Court says that is an immunity from suit, not just a defense to liability. The whole point is to avoid the trial itself.
So the entire case hinges on this. Is Yearsley immunity like qualified immunity, a true immunity from suit? Or is it just a regular defense, like I didn't breach the contract, that you can only appeal after the trial is over?
This case starts at an Immigration and Customs Enforcement ICE detention facility in Aurora, Colorado. The GEO Group, a private contractor, operates this facility for the federal government. A class of individuals detained there sued GEO. They brought two main claims. First, that GEO's detainee housekeeping program amounted to forced labor, violating the Federal Trafficking Victims Protection Act. And second, that its voluntary work program, which pays $1 a day, constitutes unjust enrichment. GEO moved for summary judgment, arguing it was protected by derivative sovereign immunity. It claimed Yearsley shielded it because ICE directed it to implement these exact policies. The district court rejected that argument. The judge looked at the contract and the evidence and found that ICE had not required GEO to implement the challenge policies and that GEO retained discretion. Now, under normal rules, the case would just proceed to trial, but GEO argued this was a collateral order and appealed immediately to the 10th Circuit Court of Appeals.
The 10th Circuit dismissed the appeal for lack of jurisdiction. It focused on the second Cohen prong, separability. The court found an overlap between the immunity question and the merits of the case.
Wait, so you're telling me the 10th Circuit found the issues weren't separate? What's the overlap?
The 10th Circuit reasoned that to decide the immunity claim, did ICE direct the action? The court would have to look at the same facts as the merits claim. Was the action lawful? Because the issues overlapped, the court found the order was not completely separate, and therefore not immediately appealable. And that's a huge deal, because this created a deep circuit split. Some circuits, like the 2nd and 6th, permit these appeals, while others, like the 9th and now the 10th, do not. So, to resolve this clear split among the circuit courts, GEO petitioned the Supreme Court, and the Supreme Court granted certiorari. Notably, the court also granted the Solicitor General's request to participate in oral arguments as an amicus curiae, supporting respondents.
Let's get into the arguments. GEO, the petitioner, argues this is a simple case based on precedent. They claim Yearsley provides a true immunity from suit. They draw on the court's longstanding recognition that contractors obtain certain immunity. They point heavily to Filarski versus Delia, where the court gave qualified immunity to an individual contractor. Then, petitioner point to Mitchell versus Forsyth, which held that denying qualified immunity is immediately appealable.
GEO's logic is Filarski plus Mitchell equals appealability for contractors. They argue the 10th Circuit's overlap reasoning is just wrong. Mitchell itself expressly rejected the idea that any factual overlap kills an appeal. The immunity question, was it directed, is conceptually distinct from the merits. Was it illegal? And GEO brings the big picture constitutional argument. They warn that if contractors must endure expensive, politically motivated lawsuits, the government's ability to function will be hamstrung. Contractors will decline to perform as specified, or just raise their price. They argue this allows the judiciary to frustrate policy choices constitutionally assigned to the other branches.
So, how do the respondents, Menocal, counter that?
They come out swinging. They argue derivative sovereign immunity doesn't even exist.
Wait, what? How do they deal with Yearsley?
They say GEO misreads it. Sovereign immunity, they argue, is non-delegable. It belongs to the sovereign alone. Yearsley, they claim, never mentioned immunity from suit. It just said the contractor had no liability.
Ah, the classic immunity from suit versus defense to liability distinction. So they're saying Yearsley is just a regular merits defense. You can argue it at trial, and if you lose, you can appeal the final judgment.
Exactly. They argue this fails Cohen's third prong. It is effectively reviewable on final appeal. And they say it fails to serve a value of a high order, pointing out that even the government has argued in the past that these orders aren't appealable. And the U.S. government, as an amicus friend of the court, actually supports the respondents here.
Yes, which is fascinating. The U.S. makes a very clean argument. It says a true immunity frees you from a lawsuit whether or not you acted wrongly. But the Yearsley defense only protects you if you acted lawfully. That is, within the government's valid delegated privilege. Therefore, the government argues it cannot be a true immunity from suit. The U.S. also says GEO's analogy to Mitchell and qualified immunity is flawed. Qualified immunity does protect an officer for unlawful conduct as long as the law wasn't clearly established. Yearsley has no such feature.
So, how does GEO punch back in its reply?
They say respondents and the U.S. are attacking a grand straw man. GEO says, we're not claiming the government's total, embracive immunity. We're claiming the conditional immunity the court has always recognized for contractors. And they hammer the Filarski point. They say, you can't ignore Filarski. That case gave immunity to an individual contractor. Mitchell made that immunity appealable. GEO argues that a corporation is no different than an individual for this purpose.
This sets up a fantastic oral argument. The first thing I'm listening for is how the justices treat Filarski. Does Filarski's grant of qualified immunity to an individual contractor mean all contractor immunity claims, including Yearsley, are immediately appealable?
I'll also be looking for how the justices handle the Mitchell precedent. Mitchell did allow an appeal despite factual overlap. They must square that. Does GEO's claim, was it directed, feel conceptually distinct enough, or does it feel too much like the merits? Was it legal?
I'm also watching for the what this really means is questions. I expect some justices to ask about the practical consequences. If GEO wins, does every federal contractor get to immediately appeal anytime they lose a pretrial motion? That could flood the appeals courts.
But if GEO loses, does that mean private companies will be terrified to take on controversial but legal government work, knowing they face years of litigation with no quick off-ramp?
This is a classic battle of the bright lines. GEO wants a clear rule. Denial of immunity equals appeal. Respondents want a clear rule. Yearsley is a merits defense, so no immediate appeal.
I hope we showed why this case, GEO Group versus Menocal, presents as an important case, not simply a dry procedural dispute.
It directly affects thousands of companies that do business with the federal government. It's about who pays the price for controversial government policies, the taxpayer, through higher contract prices to cover litigation, or the private company.
A win for GEO strengthens the hand of government contractors and, by extension, the government's ability to implement policy through them. It confirms a powerful procedural tool to end lawsuits early.
A win for Menocal is a win for plaintiffs. It means contractors who claim, I was just following orders, cannot just pause the entire case for years. They must actually prove that defense at trial, just like any other defendant.
It's a huge case for federal jurisdiction and the practical reality of our modern privatized government. We will be sure to cover the oral arguments and the final decision.
That's it for today's episode. In our next episode, we'll preview Rutherford versus United States, a criminal case that will attempt to answer whether the Second Circuit erred in recognizing extra-textual limitations on what information a court may consider when determining whether there exist extraordinary and compelling reasons warranting a sentence reduction under Section 18 U.S.C., Section 3582, subsection C, paragraph 1A. Don't worry, we'll break it down.
Thanks for joining us on SCOTUS Oral Arguments and Opinions. If you enjoyed this episode, please subscribe, rate, and share. Talk to you soon.